You're back within focus. There are concerns that domestic workers are being systematically excluded from claiming from the compensation fund for work-related injuries, illnesses or deaths because of challenges, including a lack of enough time to lodge claims. This comes after the Constitutional Court made a landmark ruling in 2020 that declared unconstitutional a law that excluded domestic workers from claiming from the fund. Now, to give us more details on this, I'm joined by researcher at the Socio-Economic Rights Institute of South Africa, Kelebogile Khunou. Kelebogile, good evening and thank you for your time here on In Focus. Domestic workers have literally less than 5 to 6 months left to lodge their claim. Was the commissioner unreasonable in giving them 12 months to lodge these claims?
Thank you so much for having me on your show. As you mentioned, the time limit that has been given for domestic workers to launch their claims for occupational injury is unreasonable. And this is because we are dealing with a court case that was handed down, the judgment was handed down 6 months ago, but we're also dealing with an occupational group that has been historically marginalized. And so with this background, it should be accepted that domestic workers will need more time to be able to lodge their claims. On top of that, even before the time limit is extended, what is really needed is an educational campaign for domestic workers and for employers of domestic workers to learn about the inclusion of domestic workers in this law. The good news is that the Department of Labor, in their response to submissions on the amendment bill of COIDA, which was a process that took place earlier this year, have responded and said that there is a possibility for transitional provisions to be included into the Act to accommodate for the situation of domestic workers. And what we're really hoping for in the next few weeks is an announcement from the Department of Labor declaring this date for retrospective claims as extended.
Yeah. Now let's look at the process that was followed then itself. When this, of course, court judgment came out in 2020, it was declared a huge victory. Was there an obligation put on the compensation fund itself to educate domestic workers on their rights and what the process that is going to follow will be? And did they do any form of education on what that process is going to be?
So at the institution really that is responsible for educating employers and employees in different works, including the domestic work. The Constitutional Court in its judgment was very clear. It granted COIDA immediately and retrospectively, which really highlighted the importance of this inclusion, as well as the injustice that was experienced by domestic workers of South Africa. And so as the institution that is responsible for the sector, I think there is an expectation that an educational campaign which is systematic, that reaches all provinces of South Africa, all domestic workers in South Africa, as well as their employers, should be launched by the Department of Labor to enable domestic workers and employers to know about their rights and their obligations under COIDA.
Now, the unions have said that they've reached out to the Department of Labor to request a workshop of that nature to inform domestic workers, teach them how the COIDA works, what the claim process is going to be. They're saying, of course, that request has fallen on deaf ears, except for a briefing that was done by the Department of Labor. Is that enough?
Definitely not. I think that, you know, when the unions talk about making an effort to reach out or to engage with the Department of Labor, we really should understand that it's been decades and decades and decades of work, of really trying to open up a dialogue and for them to have their needs heard. So it hasn't been enough. And so we're hoping that this next stage after the court case, really we're going to see a collaboration between the employers of domestic workers, the Department of Labor itself, as well as the unions, to enable domestic workers to benefit from the compensation fund should they experience occupational injuries or diseases.
Yeah. How complicated is this retrospective claim process?
So it is complicated in that, so what the retrospective application means is that the declaration of invalidity of that specific section in COIDA is applied retrospectively to 27th April 1994, when the interim constitution was introduced. And so this means essentially that any domestic worker who has a claim from 27th April 1994 up until the date of the judgment, when it was handed down on the 19th of November, is actually able to go forward and put in a claim for an occupational injury, or the dependents of a domestic worker who has died is able to put in a claim so that they can be compensated for his or her death. The complication is that there are several supporting documents that are needed to be able to claim from the compensation fund. You need to be in a position where your employer actually does the registration, and they are the person who's actually responsible for lodging the claim and following up and communicating with the commission. And so if you think about a claim that could come from 1997, for example, where the employer might not be reachable or might not be willing to participate in this, where medical records may not be found. This is the situation where domestic workers are in right now. And so what we're hoping to see in the transitional provisions that the Department of Labor is speaking about is a mechanism to support domestic workers who may not have the supporting documents. Perhaps a creative way to prove one's illness or one's injury, maybe by signing affidavits or identifying witnesses who can come forward, would be allowed by the Department of Labor, so that domestic workers are actually able to lodge their claims and submit their claims and have those claims processed.
Yeah.
So that's the difficulty in this situation. But we also need to remember that it was an injustice. When we think about the labor movement in South Africa and all it was able to achieve, it really is a blight on that landscape for this group of workers that was very active in the labor movement to have been excluded in the first place. Right now, as a researcher, if something happens to me at my workplace, I am covered. But a domestic worker, before this judgment was handed down, wouldn't have been able to be covered by COIDA or claim. And so this was an injustice, and it's not the fault of anyone else, except that we need to take ownership of this exclusion and try to really find ways to redress this injustice.
Yeah. Now, there are 7 recommendations that you have come up with, Seri. Have you forwarded these to the Department of Labor? These include launching an educational campaign, but also an extension on the lodging of retrospective claims.
Yes, so we actually met with a few organizations and some of the unions that have been involved with the Mahlangu case, which we worked on, as well as just in terms of domestic workers issues in general. And we have come up with advocacy messages that we want to put forward to the Department of Labor. And we're hoping that we will be given the opportunity to sit in a room with the Department of Labor to discuss.
And is there any response? There's no response, are you saying, so far, or even an acknowledgement of your letter?
So we haven't written this letter yet, but in terms of previous letters, when the notice from the Compensation Commissioner was issued, we did write a letter to highlight the injustice of this deadline for retrospective claims. Yeah. And we did not receive a substantial response.
Okay.
But what we're happy about is that the Department of Labor, in its response to the submissions for the COIDA amendment bill, and this idea that there will be transitional provisions, we are hoping that will supersede this what was written in the notice about the deadline for the claims, and that part of these transitional provisions have to do with what I mentioned before, making it possible for those people with old claims who might have challenges in accessing medical records or their employers, that we receive information from the Department of Labor that can make that process easier for domestic workers to lodge their claims.
And how long are you expecting this extension to be?
So I think the first thing that needs to be done is that we need to gain information about how many retrospective claims are out there, or how many injuries or diseases are being contracted by domestic workers. And so the need for a dialogue really between employers, between domestic workers and the Department of Labor is really important, because that's where we will get this information, which would then be able to say, well, what is a reasonable time period to expect domestic workers to come forward with their claims. And so really, I think at the heart of our challenge is the need for dialogue. I think it's high time that we're no longer on opposite sides of the fence, but rather that there is this dialogue between the employers who are responsible for registering and making contributions between employers, domestic workers, and the Department of Labor, which is responsible for enforcing compliance with domestic worker laws.
Kelebogile, I appreciate your time. Thanks for joining us tonight on In Focus. Researcher at the Socio-Economic Rights Institute of South Africa, Kelebogile.